Hello and welcome to SEO Daily. In this episode, we bring to you updates from days 8 and 9 of the hearings in the challenge to the abrogation of Article 370. On these 2 days, which were the final days of petitioners' arguments, the bench heard arguments from 12 counsels. On day 8, the bench heard arguments from Senior Advocates Dinesh Dwivedi, Singh, Sanjay Parikh and P.C. Dwivedi argued that the accession of Jammu and Kashmir to India did not mean that the state was stripped of all its powers. It was not a merger but an accession, and with that came the retention of some autonomy and independence. This autonomy, he said, is enshrined in the Jammu and Kashmir constitution. Dwivedi went on to make a novel proposition in the case so far, that once this expression of autonomy was made, the whole of Article 370 ceased to operate. The bench resisted this argument. Chief Justice D.Y. Chandrachud pointed out that if this view was accepted, the court would effectively be stating that the Constitution of India stood frozen after 1957 when the Jammu and Kashmir Constituent Assembly was dissolved. This would mean that the Indian Constitution would not apply to Jammu and Kashmir. Agreeing with the Chief, Justice Khanna also pointed out that Dwivedi's arguments cut through the points made by the other petitioners, who had argued that after the Constituent Assembly dissolved in 1957, Article 371 survived, through which India could make laws for Jammu and Kashmir with the consultation and concurrence of its people. This provision was what gave legitimacy to the various presidential orders that have been since passed. Justice Kaul asked, since 1957, so many presidential orders under Article 370 have been passed. Had no one thought about this? Dwivedi answered that every law passed in relation to Jammu and Kashmir since 1957 got its legitimacy from the Jammu and Kashmir Constitution itself. With this argument, Dwivedi seemed to insist that the basis for the relationship between India and Jammu and Kashmir comes from the state's own constitution and nothing else. Senior Advocate Chandrauday Singh appeared next. His arguments were focused on the reorganization of Jammu and Kashmir into union territories after the abrogation of Article 370 in 2019. He submitted that the president could not alter the status of Jammu and Kashmir even if the state is under president's rule. The president's power under Article 365 was limited. Senior Advocate Sanjay Parikh referred to Jammu and Kashmir's 1944 Naya Kashmir Manifesto. According to this manifesto, the people of Kashmir came together to express their desire to remove the monarchy and have a democratic constitution. This desire was communicated to the Maharaja and was ultimately translated into the Jammu and Kashmir's constitution. This written constitution, he said, was supreme and could not be ignored as a sign of the state's sovereignty. The last counsel to argue on day 8 was Senior Advocate Prashanto Chandrasen. He was the first counsel in 8 days to highlight that the population of Jammu and Kashmir consisted of a Muslim majority. He argued that the people of Kashmir had the choice of either being a majority in Pakistan or choosing to take a minority status in India. And it chose the latter, demonstrating a conscious choice to remain a minority. To respect this choice, there was a constitutional promise to protect this minority in the form of Article 370, and thus the provision must be interpreted strictly. On day 9 of the hearings, 8 counsels appeared before the bench. Senior Advocate Nithya Ramakrishnan argued that Article 370 was a sui generis power vested with Jammu and Kashmir. Senior Advocate Menka Guruswamy argued that the provision reflected the constitutional intention to offer a unique brand of federalism to Jammu and Kashmir. Advocate Varisha Farasat argued that Jammu and Kashmir is unique because while most Indian states represent a holding together kind of federation, Jammu and Kashmir represents a coming together federation. This system for Jammu and Kashmir is enshrined in the constitution through Article 370 and must therefore be interpreted strictly. Advocate Irfan Lone, Mr. Zahur Ahmad Bhatt, Senior Advocate Muzaffar Hussain Beg attempted to highlight the ground impact of the abrogation of Kashmir. Lone contended that the sentiments and aspirations and the will of the people is enshrined in Jammu and Kashmir's constitution. Bhatt, a petitioner, appeared for himself. He argued that the dilution of the special status of Jammu and Kashmir into union territories is a violation of constitutional morality and national interest. Mr. Beg read excerpts from A.G. Nurani's book, Article 370, A Constitutional History of Jammu and Kashmir, to argue that the abrogation is unconstitutional. Senior Advocate Gopal Sankaranarayanan was the last person on the petitioners list to argue against Article 370. He focused on filling in the gaps in the arguments made so far. He stated that Article 370 was always designed to be permanent and argued that the words used in the provision are crucial to interpreting it. He reasoned that the words consultation, concurrence, and recommendation used in this provision were crucial in interpreting the Constitution. The word consultation meant the meeting of two minds, that is, Jammu and Kashmir's people and the Union. The word recommendation, he said, was meant to establish a system of balance. A recommends to B, he said, was the proper way to maintain this balance. But in this case, through presidential orders, A was telling B what to recommend. With this, the 18 counsels on petitioners' side concluded arguments against the abrogation after 9 days and over 40 hours of hearings. Stay tuned to SCObserver.in for more updates from the Supreme Court. Thank you for watching.